Hello everybody and welcome to today's webinar. So I'm Sarah Collins and I'm from the New South Wales CIPS committee. I'd like to welcome you to our session called Current Legal Issues in Procurement. So first of all, I'd like to begin by acknowledging the traditional owners of the land on which I'm on, the Gadigal people of the Eora Nation, and pay my respects to elders past, present and emerging. I'd also like to extend that respect to any Aboriginal or Torres Strait Islander people joining the webinar today. We've had a great turnout for this webinar, which I appreciate everybody, especially on a Monday. We've got over 130 participants, so clearly a lot of interest in this topic. And for those of you who don't know who CIPS are, because I believe we've got a number of guests who've come on the invitation of our speaker. So CIPS is the Chartered Institute of Procurement and Supply, and it's our global professional body in the procurement and supply space for professionals. And it's dedicated to best practice, continuous improvement and promoting standards and raising awareness in our practice, which is an awesome practice and profession. And anyone who knows me knows exactly what I'm about to say next. We work in an awesome area and procurement found us. Please never use the expression that you fell into procurement. It's my byline that's going to be on my gravestone. And look, we really believe that procurement has a really big place it can be with regards to social change and impact. And this webinar really will help you understand some of the things in that particular space and where legislation and current trends in procurement really are leading the way we spend our money, and we provide that sort of social and economic support within suppliers and regions and communities, etc. And by example, an example there could be a reconciliation action plan and how procurement has a really big place we can play in that. So I'm just going to start with a few housekeeping rules. So this webinar is being recorded and it will be available to people afterwards on the CIPS YouTube channel if you want to rewatch it or share it with anybody. We have two communication channels throughout the webinar. We've got the Q&A channel and also the chat channel. So I ask that if you've got any specific questions, can you please put them into the Q&A channel, not the chat channel. One of my wonderful committee members, Zoe, is helping to monitor that for us. So we will make sure we are reviewing all your questions and we try to get to them at the end. And also, if you do have any specific questions for the panelists, I know there's only one panelist in this case, but anything that has come up, you can just sort of identify that in the questions that you ask, or make it easier for us to target questions in that space. And also in our chat channel, I encourage you to just sort of say who you are, where you're from, what land are you on today, just general sort of chat amongst yourselves, because we do appreciate in these virtual sessions, it's a little bit hard to do the networking. So please use the chat channel as your chance to do the networking. So I'm now going to introduce our speaker for today. So Scott Alden, who is a partner at HWL Ebsworth Lawyers. Here's his lovely mugshot, stolen off LinkedIn. He does look like that, honestly. I have met him in real life. It seems very strange to say that about people now that you've met them in real life. So Scott has over 20 years experience and he specialises as a legal advisor on significant projects and procurements, primarily for government, but also private sector clients. In recognition of his position as a leading government lawyer, Scott was one of the first New South Wales Law Society accredited specialists in government and administrative law, with a focus on government, commercial and procurement transactions, and has been appointed by the Law Society of New South Wales as the head assessor for the specialist accreditation this year. Scott also writes and lectures 2 procurement courses for the master's programs at both the College of Law and the University of Melbourne. Scott also has a special interest in contract law, particularly for major projects, and is a member of the Australian Advisory Board for World Commerce and Contracting Association, which a few of you might know as previously the International Association for Contract and Commercial Management, or the IACCM. I first met Scott actually a couple of years ago when the Modern Slavery Act was still being negotiated, and he was starting to do a lot of sort of briefing sessions to the industry then. So, he's got a lot of knowledge in this space, and I'd like to welcome Scott to the panel today.
Thank you, Sarah. Let me just,
Coming.
Okay, thank you, Sarah. Here I am.
All right.
Thank you
I was
very
a bit worried, disappeared on me there.
I know, just technology is great, isn't it? Thank you very much.
Right.
And thanks to CIPS for organising this great webinar today. And it's my pleasure to give an update on procurement, a few things to go through, a few things to talk about, which I will do.
That's great.
Yeah.
So what made you want to present on this? Because we do have a number of things you're going to touch on, things like payment times, small businesses, modern slavery, COVID impact. I guess what made you feel this was a good time to be briefing the procurement community on a number of these topics?
Well, I love procurement, like we all do. I think, as you say,
and you didn't fall into it; it found you.
It's right. I think it does. It's a calling, and it's constantly. It's always interesting. It's always been a very interesting and evolving area for me, and I think never more so than now, actually, in terms of just the changes that happen and the changes that have come through of recent times. And I'm often asked by clients, how do we keep up to date, keep up, what's new and what's happened. And so I thought, well, sort of bringing together a presentation of things that have happened as recently as 2 days ago, and perhaps as long ago as 6 or 9 months ago, is a useful thing just to get it all together in one place for people to get that a really important update as to what's going on across many areas, whether it's reporting, execution, contract types of contract use, modern slavery, legislation, all of that. So we've got about 8 to 10 sort of topics to just briefly touch on and introduce. Obviously, we can do a deeper dive another time, and we can have some of that through the chat and the Q&A as well.
Right, well, I'll hand it over to you. So Scott's going to talk to you all for about 30 or so minutes, and then we'll have a chance for question time at the end. So as I said, keep shooting your questions through. Thanks. Over to you, Scott.
Okay, thank you. All right, let me just get this back to the beginning. Here we are. So current legal issues in procurement. As I say, there's just been so much happening, some of which of broad application to both private and public sector, some of which only to private sector and not so much for government, and some to government and not so much for private, and then some of it sort of state-based. So we'll just zoom through all of that, because I know we've got a variety of people from a number of places today, both public, private sector, and also some from overseas and our friends in New Zealand. You'll have to forgive the little hair flick here. It's just a bit short on haircuts, as all of us are. So anyway, moving through onto our first little update here. And this is one of my favorite pictures. I've got another favorite picture coming up actually a bit later, but this is one of them because it evokes for me really what modern slavery is all about in terms of treating human beings as commodities and commoditizing them and not giving them the freedoms in terms of their labor particularly. And it's been a pretty fast-paced area, modern slavery, over the last 12, 18 months. And we saw there's been a whole lot of modern slavery statements uploaded. There's been a lot of contracts changed to bring the modern slavery requirements into them. And we have also now starting to see remediation practices for organizations. And really that's the next step, I think, for modern slavery is how organizations remediate found modern slavery, because it began with legislation requiring large corporations to report, and that's largely done. It needs to be keep on going, and we need to sort of dive a bit deeper into that year on year. And no one expected everybody to do everything in year one, so it's a bit of a planned approach to modern slavery. But what we got to do now is to sort of move the dial from just reporting to then doing something about it. Because people say to me, well, what's next for modern slavery then? So we've reported, what do we have to do now? And there is a recognition by government that people need help. And there are some great guidelines that have been issued by Border Force, Department of Home Affairs in the last month or two, giving guidance on remediation practices for organisations where they have found instances of modern slavery, remembering that the knee-jerk approach to terminating a contract and disengaging with a supplier just because there may have been some found modern slavery is not actually recommended. It is a sort of last course of action. The recommendation is remediation, education, working with organisations to improve. So that's that image there. The other thing that we had, as I say, some of this stuff is so new. So in the last few days, we had the Senate pass a bill on forced labour. So the Customs Amendment Bill, banning goods produced by forced labour, the Customs Amendment Bill 2021, passed through the Senate on the 23rd of August, so just a week ago. And what that will do when it comes into force is to amend the Customs Act 1901, prohibiting the importation of goods produced in whole or in part by forced labour. So we won't be able to import those if and when this is passed. A couple of interesting things to say about that is this is not just going to apply to large corporations, it'll be for everyone. So this is different, therefore, to sort of a modern slavery approach. And in fact, it's very different. It's not just about reporting, finding, and working with. It's actually stopping something. And it's been on the agenda for a little while. There was an attempt to push this through last year in relation to Xinjiang and the Uyghur people in particular. And it was very specifically addressed to that at that time, but it did not pass, possibly because of that specificity. But this more general bill has been passed, which is a good thing. And it applies to all Australian companies, not just those, as I say, captured by modern slavery laws. The concept of forced labour is basically where anybody, through fear, coercion, threat, deceptions, or whatever it is, would consider themselves to not be free. That is, free to stop working or to leave their work if they wanted to. So that's what that's about. And obviously there are places around the world where that is prolific, and it's those kinds of places that Australia is seeking to clamp down on and basically stop importation of goods. As we see at the next bullet point here, the news recently, there's a lot of pressure on the National Health Service. So that's their public health system in the UK to not procure $5 billion worth of PPE from companies who are implicated in forced labour in China's Xinjiang region. So this is a global issue, and it's countries like Australia, the UK, the US, who can bring to bear the sort of economic pressure to stop this kind of thing happening in the only way that we can, using those economic means and trade and commerce means. So that's the forced labour bill. Now, I haven't got much to say about modern slavery in New South Wales. It has just been such a troubled journey, really, being the trailblazer and the leader of modern slavery in Australia. It sort of fell over at the last hurdle. When it came to actually be implemented, it was seen that there were some significant issues with it, both in terms of application and in terms of validity around certain things that it tried to do. And that has bounced around within government, gone off to a social standing committee, had a long report done, received submissions. I wrote a long submission about it, how it can be improved and corrected, and it's still there, just sort of in that place, really. And I know that New South Wales government and others have got other things to deal with right now, as we see every day at 11 o'clock with Gladys and the team giving us the COVID update. So, you know, there are other things, but this is something that has just been languishing for, I think we'd all agree, too long. So the update is that the discussions, so what they're trying to do is to harmonise the laws so that we don't have two parallel laws with different obligations and different requirements. So to try and harmonise them so they work well together. And but the trouble with that kind of thing is, as we have seen, in relation to COVID and many other things, government does not, in Australia, tries to work together and harmonise and have commonality of approach to things, but doesn't have to. And where they don't want to, they can really dig their heels in, and that can be a problem. So who is going to capitulate in relation to some of the differences between the two acts, for example, the Commonwealth Act and the New South Wales Act? Well, New South Wales would like to see the threshold at 50, and I'm sure the Commonwealth would like to maintain it at 100 million, to pick one difference between the two regimes. So they are trying to harmonise, and they are wanting to find areas of commonality. So the idea now is, most recently, is to try to pass into law those things that are not inconsistent with the Commonwealth Act. So what it wants to do is to commence components of the New South Wales legislation that complement Commonwealth and not inconsistent, and that should be easy. So that's really the main focus now, and then we can move on to look at other things where we might try to harmonise a bit differently, or one has to change, and who knows which one. Okay, so that's modern slavery. That's a bit of an update there. As I said, a couple of other updates with modern slavery. One, reports are in and statements are in. So if you want to search an organisation's modern slavery statement for interest, you'll find it on the Border Force's modern slavery websites. So you can do that. And they've also produced some guidance for what next. And I guess the last thing to say about this is, we're into year 2 now, and companies can't take their hand off the tiller. They really do have to look at what they're going to do better next year to evolve the modern slavery reporting journey that they started, rather than just change the date on last year's modern slavery statement and publish that as their 2022 statement. That really isn't appropriate and isn't what government's going to like to see either. It probably would comply, though, with just looking for compliance. But the whole point of this stuff is we need to do better than mere compliance. We need to improve along the way. Okay. Next. Now, who doesn't like to get paid quickly? This has been a long issue for a long time. Is the speed at which organisations are paid, and it really started, I suppose, about 22 years ago in some respects with the security of payment legislation, because that was all about conditionalised payment and slow payment for small subcontractors in construction who would then go insolvent because they would wait around as the last step in the ladder paid last. So you have all these pay when paid clauses and everything else. And they've been done away with through the security of payment legislation, which also introduces, by the way, quick payments. So contractors have to be paid within that legislation within 15 days as a requirement of how quickly they need to be paid. Now, this legislation, which has come 1st of January this year, so the payment times reporting scheme, actually isn't about forcing people to pay quickly. It just forces them to report on how quickly they do pay, and also what proportion of organisations they engage with who are small businesses. So very recently, we had some guidance published at treasury.gov.au. So the Commonwealth Treasury Department published some guidance for reporting entities, because there's a bit of, it's a little bit confusing really as to what is needed and when, and also how do you identify what is a small business or a large business or whatever. So that kind of thing as well. So what the aim of this legislation is to do is to improve payment times, as it says. It touches on both government enterprises and large corporations. So both of them have to do this. So that's Commonwealth government enterprises and also large corporations. And we'll come to the next slide as to what that is. And it requires them to report small business payment terms and times. So what do they say they'll do, and then what do they actually do? And it requires those reports twice yearly. So it started on 1 January, and the first report will be due 30 September for those with a 30 June financial year. So our first report is coming up 30th of September, if you have got an Australian financial year being 30 June, 1 July to 30 June. Okay. Now let's move on to the next slide. So it applies to companies, like I said, with turnover of over 100 million. So constitutionally covered entities that carry on business in Australia and have an annual total income of more than $100 million. We've had to give some advice to clients about this already, and I've been leading that here about some corporations. It's hard to really, well, they find it difficult sometimes to see whether or not it applies to them. So there are some confusing semi-government organizations, for example, that wonder whether or not this applies to them. And then there are other types of entities that just wonder what income really means for them, particularly those in the financial services space. So that's been a bit of an interesting journey. It applies then also to controlling corporations where the total income for all members is more than 100, and then also to subsidiaries where an income is over 10 million, but the group's got over 100. So there's a few different tests here, really, is the point. And those you need to understand, or you need to sort of work out and identify whether or not this applies to you. And if it does, then, as I say, the sort of clock's ticking in relation to getting those reports in. The first reporting period, as I say, closing in September, just next month. Even those entities, by the way, who don't fall into the definition, so those that are underneath these thresholds can opt in if they want to. Right, so what the reports need to include are details of standard payment periods. So what does your contract say? 30 days, is it the end of the month in which, or the month after the date the invoice was received, all these funny things that you see in contracts. It then asks you to detail changes to payment periods. So if you've gotten quicker or slower, or the change from last period to this period. It then requires you to provide a proportion of invoices paid across various times. That is within 20 days, between 21 and 30, 31, 60. You see there on the slide the frameworks or the parameters for reporting. So that's all about the payment times. The next one is about the proportion of all procurement from small business suppliers determined by total value. So of all the things that you spend money on, how much of that came from small business? And then there's a few other details. Now, there are penalties for this, unlike certain things. So unlike small modern slavery, for example, where there aren't penalties currently, although that is on the agenda to change. One of the things that New South Wales had, in fact, was penalties for not reporting or whatever else, but Commonwealth doesn't. Here, there are penalties. If you don't report, 60 penalty units. And if you provide a false report, 350 penalty units. Penalty units, I will come back to in a moment. But they're like $100, $200, $220, I think, at the moment. I can just check that. But that's basically a fine that you will get. Okay. This wonderful slide here is all about small business and big business. So small business unfair contract terms. So we have had the small business unfair contract terms legislation around for quite some time, as you would know. All right, so the penalty units are $222 per unit, by the way. Okay, so we've had small business unfair contract terms legislation around for a little bit, and so people are pretty well used to it. However, it isn't doing the job, really, that it was designed to do. And so what the government is looking to do now is to change that. And there's a bill being introduced, actually, just again a few days ago, to protect consumers and small business against unfair contract terms in a very different way than it currently applies. You'll recall, currently, for it to apply, you need a company of less than 20 people. The contract value has to be less than $300,000 or less than $1 million if it goes for more than 12 months. So it's less than 20 people, so small business, small value, less than 300 grand. And then it needs to be a standard contract. And there's been a bit of confusion about that, which I'll come back to in a minute. And lastly, it needs to have unfair terms in it. And that's, again, a bit of an up for grabs as to what an unfair term is, but some are obvious and some less obvious. So that's had a journey so far, about 4 or 5 years it's been in place. People understand it. It hasn't had much to do, though, because it takes a lot for a small business to bring a legal challenge against a client of theirs saying that their contract's unfair, and then they're going to force an injunction against that entity, restraining them from applying that clause. You know, whilst it's not that expensive, it's frightening. You'll lose business and you'll do all sorts of things. So what are they going to do? Well, the first thing is, at the moment, having unfair terms in your contract is not unlawful as a matter of just putting it in. You can put them in and it's not unlawful. They want to change that so that it is. So you can contract with unfair terms in your contract. You are allowed to do that. It's not against the law to do that. But if you do that, you run the risk of those clauses being rendered void and then non-enforceable. So, it's a slight technicality, I suppose, but actually going to market with an unfair contract is not unlawful. Well, they want to change that and to make it unlawful. The next one is the court will have flexibility to impose different remedies, compensation, injunctions against corporations from engaging in conduct going forward, rather than just one-off contract by contract approaches. There's a few things in that. These next 2 or 3 are really significant. So it will apply to companies that not only, where it used to be 20, it's going to be 100. So that's going to really open up to much more companies who might be affected or affronted by small business. This will really open that up to far more. That's going, 20 to 100 employees. That really is a game changer. The next one they want to do is to have an alternative, because some companies might have not passed the employee threshold, but they may have a low income or low turnover. So they might have 200 people, but they might not earn all that much money. So they should be designated a small business as well. And I've been onto this from the start, which is, it's a bit of a kind of inappropriate test, really, or it's a blunt tool where you say, well, let's say everybody under 20 is small and everybody over 20 is big. That's not really the case. Some organizations can employ a lot of people, not-for-profits, for example, whatever else it might be, but turnovers can be quite a lot lower. And so they've got this $10 million or less test now as an alternative to where you don't pass the headcount test. The other thing is, if you were a small business, then if your contract value was over $300,000, and it doesn't take a lot to get there in some cases. So if you're talking about large projects, for example, you might be a small specialist business, small specialist subcontractor with only 15 people involved, but the contract could be for a couple of $1 million. Well, you're out. You can't use this legislation. They want to remove that test as well. So taking away the upfront price payable threshold altogether. So again, that's a really big deal. The last couple are just to clarify what standard form contract is. Remembering, a standard form contract is not just a contract that's published by the Australian Standards Committee, for example. What it means is a contract drafted by one party, given to the other one on the basis of basically take it or leave it. So here's a contract, and that's basically what it is. A standard form contract is that. It doesn't have to be a standard published by a third party and then paid for under a license for any of that stuff. You sit there, you draft a contract, you give it to someone else, say, here are my terms. That's a standard form contract. The last point here is to make some minimum standards and industry-specific requirements exempt. So you'll take industries and have a look at them, whatever they may be, banking, shipping, whatever. There are certain types of industries that have got certain arrangements which, whilst in another industry might be unfair, for this one over the years and so on, it's become accepted as necessary to protect the one or both of the parties. So those sorts of things, there'll be some allowance for. Okay, there's a little update on SMEs. So SME, small to medium enterprise, government specific. So it's interesting when you say, well, as large corporations, should we be sort of helping out our SME friends? Well, that's really a matter for your own sustainability policies, really, rather than a matter of law. But what we have seen in the government space in both New South Wales and the Commonwealth is changes to procurement rules, basically allowing direct engagement with SMEs rather than having to go through a tested competitive procurement process. So you'll see there, the CPR's Commonwealth procurement rules allow direct engagement with small to medium enterprise up to $200,000. And the test is otherwise 80. But if you're SME, it can be up to 200. So that's encouraging small to medium enterprise direct engagement with government at an appropriately adjusted level of contract price. And that's good because tenders, they can be very time consuming. They can be very onerous. And for small to medium enterprises, without the powerhouse BD marketing team, they can just not even bother. And so if you can open it up a bit to have direct engagements with them where they don't have to go through all of that marketing circus just to get a contract, then that's a better outcome. Got a couple of new things here from our friends in New South Wales government too, which help small business. So the SME and regional procurement policy has been refreshed in New South Wales, and the small business shorter payment terms policy. So this is sort of on the back of the Payment Times Reporting Act, which we spoke about at the beginning. There's a New South Wales government policy requiring large businesses who've got government contracts of over $7.5 million to pay their subcontractors within a certain period of time, being 20 business days. So that's New South Wales government trying to apply pressure to large corporations to treat their SMEs better in terms of paying them quickly. So that's good. All right, here's our friendly COVID wrapping around the world. COVID recovery assistance. So the Australian government is providing some recovery loan schemes, again, through just in terms of updates, 25th August, they're going to change the eligibility rules for SMEs to qualify for some loans. So annual turnover of less than $250 million, an SME is able then to avail itself of a loan and from government, and that's just all about COVID recovery. Relevant to COVID as well, we have execution of documents. So we've got this is a good old-fashioned deed being sealed, signed, sealed, probably delivered as well. It's probably done on vellum, which is animal skin, but this is all of it sort of back in the day. What we do now, of course, is more and more we do electronic signing. And we've really had that was evolving anyway, but COVID's really brought that to the fore, where people are not in an office where they can sit down together, use the same pen, sign in front of each other, have witnesses there, pop a bottle of champagne and celebrate the win. None of that can happen. So what you do, of course, is you have to sign it through electronic remote means, and there's legislation that's been passed to allow for that. Most recently, there was a refresh of the Commonwealth legislation, which allows for electronic execution of deeds by statute. So there's a legislation that allows for electronic execution of deeds. And some states it's okay, and some states it's arguably not. So, it's a very confusing area, all of that. The point is you can electronically execute a contract till the cows come home, that's fine. And you have been able to forever, really. But electronic execution of deeds has always been somewhat in doubt. We've got legislation authorising that now in New South Wales at Commonwealth level, which passes that through New South Wales, Victoria. From memory, I think it's South Australia and Queensland where it's there are some question marks around that. But anyway, the point is laws are being passed very quickly to enable efficient electronic transacting in these strange times that we're in. There's a very good table published by the Australian government solicitor. They do what they call commercial notes. And I think it's commercial notes number 19, which has got a long table of how you can validly execute different types of documents in different states. And it's very good. I've used that a number of times just to remind myself of exactly what the rules are. They may or may not have been updated having regard to the thing that came through a few days ago, but I suspect that they have been. But either way, they say at the top the time that they were last updated. So I encourage you to look that up. And there's other resources around the place, but it's an interesting area, certainly, execution of documents. Well, here's that loan scheme back. So that was just an interruption to that. So that slide just was out of place, that last one a little bit. So 80% guaranteed by the government, this loan, repayment holidays, $5 million in loans, 10 years. So this should really help people in the SME space to recover from the impacts of COVID. Okay. Now here we've got Parliament House and a judge and a gavel. And that really is referencing the legislation that's recently passed affecting Commonwealth Government and New South Wales State Government and Tasmania, and it's coming to your state soon, which will allow tenderers to bring legal challenges where they are suspicious of a process that was not run according to the rules. Now, those challenges in the Commonwealth come in the form of the Commonwealth Procurement Judicial Review Act 2018, Commonwealth Procurement Judicial Review Act 2018. In New South Wales, it's the Public Works and Procurement Act 1911, and it's the enforceable procurement provisions that were brought into that act last year or year before. And I've had to advise on those things numerous times now, both to Commonwealth and to state, just about what they mean and how open those processes are to challenge. Because it allows for a very simple, quick, cheap, effective form of procurement challenge made available to tenderers like you've never seen before, like has never existed before, where they can freeze a procurement just by making a complaint, however spurious. In the end, obviously, if it is a spurious complaint, then nothing will come of it, but they can really cause havoc to an important procurement, an unhappy tenderer. So as soon as you receive a complaint in both jurisdictions and Tasmania, you have to halt the procurement, investigate the complaint. The tenderer is able to take it to court if they're not happy with the attention they're getting or the resolution of the complaint. And very quickly, a court will look at that and will give an injunction to freeze the process or to force the government to do something different to what it's doing or to comply with a rule, and also will award compensation. So, this is fundamental ground shifting for procurement like we've never seen. It's off the back of legislation around the world, US and UK in particular, which allow a very clear and easy path for tender challenges. Well, we have that here now at both the Commonwealth and the state level. So we need to be somewhat cautious about all of that and just make sure we run our procurements totally in accordance with the rules that we have. One thing I'll say is, I say it's coming to a state near you. Queensland has said they're not going to follow this, even though they're required to, because the Trans-Pacific Partnership and the World Agreement on Government Contracting that we signed up to requires every state and territory to do something about this. New South Wales, Tasmania, Commonwealth has, others will follow. Victoria said they'll address this through policy, not legislation, which is fine. As long as it gets addressed, it doesn't matter. But just keep an eye out because, as I say, procurement is moving very quickly at the moment, and this is an example of that. This is my other favorite picture, this old guy here blowing the dust off an old contract. So this is one of my colleagues picking up an Australian standard off the shelf and blowing the dust off it and using it for one of his projects. Now, I've got no problem with Australian standards, don't get me wrong, but they do need quite a bit of change, particularly the older ones, AS2124, for example. Even the 4300, 4902 do as well, just to bring them up to date with legislation, risk allocation, and other things. Probably the most important shift, though, that we're seeing is around collaborative contracting. And I think we've got some people registered from Sydney Water. They've started to look at NEC4. In fact, are using NEC4, which is an English contract, all about collaboration and collaborative contracting. So this is how it would look when we're using dusty old contracts that really aren't fit for purpose. And I suppose this is the image of collaboration, working together and focusing on project objectives. I should say, for those in New Zealand, you've been using NEC4 and the NEC suite, so before NEC3, obviously, for a number of years because and to deliver some of your public sector projects. And it's gone very well there, I understand, from the research that I've done. All right, that's a whistle-stop tour of current issues in procurement. I think I've finished on perfect timing in terms of what we talked about prior to coming on. Right, I'll stop showing my screen and we'll have a look at the questions, shall we, Sarah?
Yes, and look, there's a lot coming through, and
Good.
I'm going to try to group them as best I can in asking you. Otherwise, I'll be going all over the place. But just there's been a few here around in the I guess the fairness to some of the suppliers, especially when they're small to medium enterprises. So there's two linked questions. There's one from Prashant, and there's also another one further down from, I'm trying to find who it's from now, from Susan Hunger. Susan's one was around the high levels of insurance and could they be considered unfair terms? And Prashant's one was around the terminations for convenience. Do you sort of have any comments on those two bits and
Yeah.
especially impact small to medium enterprises?
Yep. So I would say definitely termination for convenience could be seen as an unfair term. It's one that I highlighted to government when I first looked at unfair contract terms for those 3 or 4 years ago. Was look out for anything that you are putting into your contract, for your benefit only. So any one-way clause really is susceptible to being seen as unfair. So, and you can look at a number of them. So confidentiality is another classic one, where the purchaser will put in a clause that says that the supplier has to keep everything confidential. Very rarely is that two-way. Termination clauses are often only one way as well. And termination for convenience. It's very unusual to see that being a two-way. Now, the only thing I'd say about that is one defense to an unfair contract term is where you can say that it legitimately protects your business or is sort of proportionate. And I think given the termination for convenience history, which is based on the doctrine of the doctrine of executive necessity, which basically says we're government and we may need to get out of this arrangement due to government policy or budgets or whatever reason. So we need that freedom. There could be an argument to say, look, it might look unfair, but we need it and it's proportionate and it's justifiable, and then it won't actually be declared by the court as unfair. But it certainly is one that could be looked at in that way. Similarly with insurance, definitely an insurance amount, the requirements to notify or to put people in as a named party to the insurance. There's all sorts of insurance requirements that certainly could be seen as unfair. Liquidated damages is another sort of good. There are so many, but I'm just picking out ones where people may not think, because in order to be a justifiable liquidated damage, which is for those that may not know or may not recall, it's what one party has to pay another for example, late completion, a daily amount of damages. It's supposed to represent the damage that party suffers as a result of that lateness by way of daily or weekly amount. So it's already passed that test of being genuine estimate of what the damages might be. But nonetheless, the ACCC has said that liquidated damages, albeit may not be a contractual penalty, they still might be unfair if they're high enough, or if they kick in to automatically or whatever it might be. I mean, they do kick in automatically, but they put it on the list anyway. The ACCC did publish a paper 3 or 4 years ago when this first came in, and now on page whatever it is of that document, there's a list of about sort of 15 clauses that they say, look, these are the ones that we're going to focus on, and all the ones that we've talked about just then are on that list.
Okay. Look, staying slightly on the topic still of the small to medium enterprises, there's a couple of questions in there. So Peter Zinn has asked a question about the effective definition of 20 employees and where people can easily find that. And my fellow New South Wales CIPS committee member, Susan Hunger, who's hogging the questions, but they're good questions, Susan. She's asked a question as well around whether the payment times for small businesses aligned to the New South Wales Small Business Commissioner, or is there a list that the Commonwealth uses?
Yeah, and that's great. So because people need to know where to find this stuff, because you don't know, how can you report on something unless you know they're a small business, all that kind of stuff, right? And the Commonwealth government's pretty good, I have to say. I'm not saying that state government's not, but the Commonwealth government really has got it sorted out, all sorts of things sorted out. So they have published a lookup small business lookup tool on the small businesses to support this legislation. So you can simply type in to that tool your supplier, and it will come up as to whether or not it is one that needs to be reported in that way. So that is excellent. Mm-hmm. Then the other question was, which one? So there was the 20.
The 20.
Look, that's hard too, right? So yeah. So the difficulty with that is it's FTE. So 20 people FTE. So that's important. The other, it's sort of it's a head count. That's what they say. It's a head count test. So casuals can be counted in. So this is where it starts to get a bit difficult. So if you're sort of someone who's 18 or 19 or 22, but maybe a couple of them are casuals, it can be difficult. It can be very difficult. The one thing that I've said to people is, at the very least, get the workers' comp certificate, because that says how many employees are covered. So the workers' compensation certificate says how many employees are basically insured. So that's somewhere to look. The other difficulty with all this stuff, in a way, is different organizations arrange themselves differently. So if your contracting party is a subsidiary, like a shelf company of someone else, then they may have no employees and they're a small business, even though the head business has got 1,000. So that's also tricky, is that the entity to actually look at is the entity on the other end of your contract. So
could that apply, Scott, if you've got a global company you're transacting with, but you've got an office in, say one of the capital cities with 3 people, and they've set up ABN in Australia, is that sort of thing to look out for as well? Because you're not dealing with a small business with small revenue, you're dealing with a global giant, but they're classified as small business because of the size of their footprint in Australia. Is that the sort of things that can happen there?
Yeah, and I don't know that it has yet, because it hasn't had to, because this really hasn't gained all that much traction. But now, because of this, the changes that are going to come, I think it's going to get some more focused attention, like it did when it first came 4 years ago. But then everyone, he loses steam. He's going to go, oh well, it was a bit of a storm in a teacup, perhaps, and that's why these changes are coming. But this will then refocus that. And I remember back when this first passed, there were some globals who would say that they are going to register a shelf company which will become their contracting entity, just so that they can take advantage of laws that would otherwise be closed to them. Right. And that's just tactics, I guess. It's a little bit grubby, but it's just what goes on.
Okay. Look, we've got a few questions here that are just sort of seeking some clarification around whether they apply to government or private organisations. So the first one was the speed of payments legislation. Is it just to government and their government-owned entities? And
no.
Second in that space was also around, I can't find it. It was a bit about the complaints on awarding tenders. Again, does that apply to public or private as well?
Yeah, sure. All right. So the Payment Terms Act applies to Commonwealth government entities, so Commonwealth government businesses, and any corporation with a revenue of over 100 million. So go back to the slides, and there's that goes to the constitutionally covered corporations, and that's basically a Corps Act company with revenue over 100, or as part of a group and the consolidated revenue is 100, or where it's a subsidiary and it's got 10 million or more and its owner has 100. So there's a few sort of tiers to it, but if you yourself don't earn over $100 million and you're not in a group of companies, then don't worry about it. Unless you want to opt in. Some people do, for just a part of their sustainable procurement kind of approach. Some people say, well, I pay quickly and I want to shout that from the rooftops and encourage people to engage with me, and they will, if I can say that I comply with this legislation. So people will probably opt in. I hope they do. But so there's that one. In terms of the procurement or tender complaints, that is only at the moment you can only complain about tenders run by the Commonwealth, New South Wales and Tasmania. Other states will come. But certainly isn't private sector tenders. No way. And that will never come, I don't think. But for now, it only applies to government tenders. Yep. And over certain thresholds as well. So, but like they've got to be public tenders, basically, not small ones, not direct negotiations, not every $10,000 thing here or there. There are some qualifiers. A large procurement, $250,000 or more, for example, they're the ones we're talking about.
Okay. There's a couple of questions here as well about the standard contracts. So we've got a question about, in the New South Wales government, the likes of GC21 and the Performance Management Scheme, SCM 0005. And also there's a question about the NEC4 suite of contracts. Just some questions around, I guess, with regards to New South Wales government ones, are they considered standard contracts? And
yeah, definitely.
Yeah, and also the other question was around, are there plans from the government and associated agencies to start utilising the NEC4 suite of contracts?
So, great. So all of those are standard form contracts. Most definitely they would be defined as standard form contracts, yes. Mm-hmm. Then plans by government, well, AS tried to bring out AS 11,000 2 or 3 years ago, which was going to replace AS 2124 and AS 4000. So AS 2124 was written in 1986, revised in version 2 in 1992, and then AS 4000 came out in 1995, and there's been nothing since. There's the 4902 was 1999, whatever. But since that sort of flow, we have not had anything in that space. And so they tried to, and it's well overdue, because GST, security of payment, PPSA, the proportion personal property security, so much legislation's coming. So they tried to redraft or update AS 2124 and 4000 through AS 11000, and it got so close. I got an exposure draft of it actually, which I reviewed for the various committees about 2 or 3 years ago. But in the end, unfortunately, the barristers and the engineers couldn't agree on some final tweaks, and so it just fell over. Now there's a potential it's going to be sort of rebirthed, maybe, but maybe they've missed the boat, and maybe GC21 version 2 or 3 or whatever they're up to now, and NEC4 are going to take over. GC21's fine. It's funny, I was on a call the other day with a local council client, and they wanted me to present to them what should they use, GC21 or AS4300 for their design and construct contracts. And look, at the end of the day, there's so much in that in terms of there isn't a clear answer. If there was, everybody would be using just one, rather than both of them are still quite widely adopted. So as I said to them, really, it comes down to personal preference often, the people internally, and familiarity with both industry and administrators. And that's an unhelpful question because people want answers from their lawyers, but nonetheless, it's just not that simple. NEC4, I think, is a great contract. It is modern. It is easy to administer. It contains things like collaboration, working together, best for project outcomes. It has early contractor involvement built in. It recognizes BIM, which is Building Information Management. So that is up-to-date architectural approach to design. It's got all those clauses in there, which these, obviously the standards here don't, but it's English. So am I, so there's nothing wrong with being English, but the trouble is it doesn't obviously have anything in it relevant to Australia then. So, you've got to put all those clauses in. Last month, NEC4 published Australian specific clauses to address security of payment, actually. So it's starting to become Australianized. Sydney Water's using it. I think what's happening now is people are taking a wait and see approach, really, and saying, well, let's see how Sydney Water go. And if industry is okay with it and Sydney Water have a good run with it, then I think we'll see it used more and more. And I hope that we do.
Right. Right. Look, just a couple more questions because we are getting close to the end of time, and I've left what's probably one of the areas that people have been asking the most questions on to last, because I just wanted to make sure we got through a number of those other points. But there have been a few questions in the modern slavery space, and I do know this is a topic that's got a lot of interest, and CIPS are planning on hosting a separate session in this space. But going back to something you raised at the beginning of this about the Customs Act, and there's been a specific question around with its implementation, how's that going to work given most products do come from China?
Well, yeah, exactly. I mean, we're not saying you can't import stuff from China, and no one's going to go to that extreme either. I think, though, that it may well, there may be provinces that are banned, and it'll be probably the government that will put it on a schedule to the legislation. I mean, it's only just passed at the Senate level. There's a whole lot of stuff to come yet, regulations and schedules to it, which will make it more easy to understand. And I think that the government will basically list both companies and areas that you just can't buy from, actually. And then if you do, then you're going to be breaching that law. So that's how it'll be.
So would that be like some of the trade sanctions that were in, with countries like Iran and Syria and things like that? It'll be a similar sort of thing.
I think so, yeah. And they'll probably stop, most of it will get stopped at the borders as well. And so people might try to get around that. And so to import using forged importation documents, for example, God knows. But I think a lot of it is going to be dealt with by the bureaucracy rather than leave it to the companies to do. But the companies will also probably, there'll be a list of companies in areas that you can't engage with.
Okay, it's probably emphasising areas there because people probably are going to do a panic thinking, well, so much comes from China. We're not talking about, I know we're talking about parts of China.
Yeah, exactly, and companies themselves. Yeah, exactly. Yeah, it'll be that. And so no, we would certainly have to do a lot of business with China going forward, obviously, and we'll be able to. It's fine. Yeah.
And one last question in the modern slavery space. There's been a question about that a lot of the regimes around the world are, it's the actual governments are very much into this and covering it up and records, etc. So there's been a question here specifically about some of the independent agencies who we can trust and rely on to help us go through and try and, I guess, mine into what is actually correct and what's fraudulent in some of the information that we might be seeing when we're trying to do our due diligence here on modern slavery.
Yeah, they say you're encouraged to partner with NGOs, actually in-country NGOs, non-government organisations, and sort of not-for-profit types that are based there. I think because it's so early, that stage of modern slavery compliance hasn't started yet, really. There are some organisations who are saying, well, do we have to go there ourselves and door knock a warehouse and go in and check people's employment conditions, employment contracts? And I suppose you say, well, look, in an ideal world, you probably should, but no one's expecting you to do that. And so, but what you want to do is to have other people do that for you, for example. Now, there are modern slavery consultants and also software around the place, which aggregate and do some checks and bits and pieces like that. That I know there's FRDM is one example, which is a collapsed version of Freedom. Justin Dillon, a founder of something in the US that I spoke with once in a seminar, has developed that. I understand that works well. There's Inform 365, which I know people are familiar with from over the years. They've used that. So and I'm not endorsing anything. I'm just just saying what I've come across. People use that. And they look and that can work. So yeah, I think that's really all I know for the moment.
Okay, great. Look, thank you, Scott. We had a lot of really great questions there across a lot of great topics, and I hope everybody got a lot out of it. There will be a post-event survey that we do ask you to complete, because that's what we use to help them determine how we focus these topics. But look, that's it for today. And I just want to let you know that we do have another CIPS webinar, which is again, one coming up this Wednesday, and this one's on women leaders in procurement and supply, champions of change. So this is this Wednesday, the 1st of September from 12 to 1. So if you're interested in coming to it, male or female, because remember, we're really going to have lots of great opportunities for women leaders. We need both current senior leadership, but also future senior leadership of males coming through to also understand some of the challenges in the space and what they can do to help and support future leaders. So there's a slide on the screen at the moment, which will show you where to go to if you'd like to join that one. There's also a QR code. So hopefully we'll see some of you again this Wednesday. If not, thank you for coming to our webinar. Please keep in touch with all of us on LinkedIn if you'd like to ask any more questions, and please feel free to attend any future CIPS webinars. We've got them happening all over the country now. It's one of the good things about the work from home is that we can all access all of these sessions, etc., that previously we couldn't when they were face to face. So there's a lot of great things on at the moment that you can stay connected to the CIPS and procurement community with. So thank you, everybody, and enjoy the rest of your day.